Alright, welcome to the Chapter 8 video lecture. So Chapter 8 is focused on the distinction between opposing party statements and confessions, and just further expounds upon these ideas that just had a couple of slides in the last chapter. So opposing party statement is any statement, verbal or otherwise, made by a party that can be used in evidence against them. A confession is a conscious admission of guilt by an accused. So sometimes these overlap, but sometimes they do not. A confession is an admission of the crime itself, whereas an opposing party statement only concerns a specific fact. That's one way to distinguish these two concepts. Opposing party statements are, and all of this actually is just limited by constitutional rights that are contained in the 4th, 5th, 6th, and 14th Amendments. So if we think back to last week, opposing party statement is a statement or an act that are not an acknowledgement of guilt but link you to the crime, or an acknowledgement of being at the crime scene or acquainted to the victim, or denial. Actions can also be classified as an opposing party statement, and if you fail to respond, this can also be an opposing party statement. An implied admission of guilt is if somebody else makes a statement in front of another person by accusing them of committing a crime and no reply or denial is made. This is an implied or adoptive admission of guilt. So this would work by having the person who made the accusation testify about what they said and the response. Statements that are made by an accused in police custody are usually not an adoptive opposing party statement because you are not required to say anything. So if your spouse comes up and accuses you of a crime and you're quiet, that can be an opposing party statement because usually you would respond to your spouse with the truth. However, when you are in police custody, you have constitutional rights that give you the right to remain silent. So let's shift focus over into a little more about confessions and what they look like and what is required. So first and foremost, a confession needs to be freely and voluntarily given. The accused needs to understand, have complete mental freedom at the time they make the confession. There's two reasons why this is required. First of all is that if the person had complete freedom to make the statement, then it's fair to use it at trial. Second, if it wasn't given freely and voluntarily, then the person's 5th Amendment right against self-incrimination is going to be violated, or may be violated. Additional requirements. So under the McNabb-Mallory rule or the prompt arraignment rule, the person needs to be quickly and promptly arraigned. This can exclude coerced confessions because it limits the ability to hold a detainee in police custody for an extended period of time. And so the thought is that we know that we cannot just be held indefinitely, and so if we choose to speak, that we're doing so of our own free will. We also have basis for finding a confession as forced. In Spano versus New York, the Supreme Court held that psychological pressures can render confession inadmissible, and in 1964, Escobedo versus Illinois, police interrogations can violate the right to counsel. And in 1964, in Messiah v. United States, police interrogation in the form of deliberate elicitation of an indicted person in the absence of their attorney is a violation of the 6th Amendment right to counsel. Additionally, Miranda warnings are required when all the requirements are met. So Miranda warnings came out of the 1966 Miranda v. Arizona case. And when a suspect is in police custody, they need to be informed of their right to remain silent, that whatever they say can be used against them in court, that they have the right to that they have the right to an attorney during questioning, and that if they cannot afford an attorney, one will be appointed for them. Now, this is in custody plus interrogation, okay? So, in the absence of Miranda warnings and a waiver of the right to remain silent, and the right of counsel during a police interrogation, any statement obtained by police cannot be used at trial, even if the statement is not coerced, okay? We exclude coerced confessions because they are unreliable, and even the police should have to obey the law while enforcing the law. We look at confessions under a totality of the circumstances model, or in other words, kind of a case-by-case basis, to make sure that the confession is freely and voluntarily given. So physical pressures, they're not as common today. They did a long time ago. They did used to be. There are cases that exist where defendants were tied to chairs and whipped, or there are even cases where defendants were hung from trees. That has not been the norm for a long time. Where psychological pressure can be more at issue these days, this is like mental stress, and if you psychologically pressure the defendant so much that you have coerced them, then the confession is no longer freely and voluntarily given. So this comes from Spano versus New York, where we look at particularly 4 factors. Was the official pressure by a barrage of questioning from several different people overwhelming? So they had a bunch of different people just shooting questions rapid fire at this defendant. They denied Spano's request to speak with his attorney. The interrogation lasted a long time, well into the night, and he had a friend in the force who kind of was like, well, if you know, kind of manipulated that friendship. He falsely acted sympathetic to Spano, and eventually, as a result of all these psychological pressures, he confessed. And so that is not that is psychological coercion. It crosses the line. Now, Miranda rule requires that law enforcement read Miranda warnings to a suspect before custodial interrogation. Note this does not say just arrest. Miranda really is intended to apply to suspects who are in custody and being interrogated. If so, Miranda applies. Nowadays, police departments frequently give Miranda cards to officers, and it has become very standardized over the way than it used to be in the 1960s when this was first when this was first required of law enforcement officers. So in a custodial interrogation, the officer must inform the suspect of their Miranda rights, and the officer cannot interrogate unless the suspect affirmatively waives those rights. If they invoke their rights at any time, the officer needs to cease interrogation. Now, for Miranda purposes, custody results when a person is restrained in a manner consistent with formal arrest, regardless of the situation or intent of the officer. When an officer has someone in custody and asks, secondly, what's an interrogation? So that was the definition of custody. Now let's talk about interrogation. An interrogation is either the express questioning or the functional equivalent of an interrogation, which are words or actions on the part of the police officer, other than those normally attendant with an arrest in custody, that an officer should know are reasonably likely to elicit an incriminating response. So like this can be a gesture or things like that. Miranda rights need, again, just to reinforce this concept, need to be read anytime an officer effectively places a suspect in custody and wishes to question the suspect. An officer needs to provide Miranda warnings or request a waiver to proceed with questioning. A valid waiver of Miranda rights are we have to have a heavy burden of proof that everything was done correctly. And for officers, the really important thing is that they follow procedures and are careful. If there's a doubt, then the interrogation should stop. A suspect indicates in any manner they wish to remain silent, then it needs to stop. If they say they want an attorney, then it needs to stop until an attorney is present. Now, there are two separate rules that govern resuming questioning of a suspect. One looks at someone who just invoked the right to remain silent. Another one looks at defendant who asked for an attorney. For those who ask for an attorney, generally you're going to have to wait for that attorney to arrive. There is a situation, though, Maryland v. Schatzer, where a 14-day window might be sufficient to attempt to reinitiate questioning. Now, there are a couple of exceptions to Miranda. The first is a public safety exception. Officers are allowed to ask questions to find a weapon, to secure a scene, to make sure that public safety is in order. And those questions do not violate Miranda, even if the answer is incriminating. Officers are allowed to ask routine booking questions of a suspect. And officers are allowed, when they are undercover, to ask questions that would elicit incriminating responses without first Mirandizing the suspect. So your book does a really great job working through each one of these exceptions. So I would like to talk a little bit about what happens if Miranda is violated in some form. So this comes from a court. The defense attorney is going to ask that evidence be excluded, and if a court finds a constitutional violation occurred, the evidence is going to be inadmissible under the exclusionary rule. Now, under the exclusionary rule, any evidence derived from that violation is also inadmissible under the fruit of the poisonous tree doctrine. So if the confession leads to the location of a piece of tangible evidence, that piece of tangible evidence may be excluded as well. There are some exceptions to this, like if it would be inevitably discovered, or if there was an independent source for that, things like, so it's not 100% sure, but it's possible that the confession and the tangible evidence could be excluded. Now, another exception is an impeachment exception. Statements taken by police in violation of Miranda can be used to impeach the defendant if the defendant takes the stand and testifies untruthfully. So there is an exception there. If the right to counsel is violated, the confession will be excluded as well, because counsel attaching to cases is a really important part of constitutional right, and it occurs at critical stages in the process. Exclusionary rule is used here because it's a means of discouraging police misconduct in obtaining incriminating statements from a suspect. And I really like this brief figure. It kind of breaks down the stage of the process and the defendant's rights. So pre-arrest, defendant has no rights relating to confession or admission. At an arrest, if in custodial interrogation, they have due process rights against coercion, Miranda rights to silence, and the right to counsel during an interrogation. At every critical stage in the process, the defendant has a due process right against coercion and a Sixth Amendment right to counsel. So it does a really clear job of breaking down all these intersecting constitutional rights that happen during this investigatory part of the process, where officers are piecing together information. Now, a deliberate elicitation versus an interrogation. Deliberate elicitation is when a law enforcement acts with the goal of eliciting incriminating statements. This is the intent and the purpose, and that's why it is excluded. All right, so we are going to go ahead and stop the video lecture here. There are a few more slides. I do recommend that you work through them. The bulk of these slides are dealing are kind of practical things that law enforcement officers and future law enforcement officers should consider as far as a preamble to an interrogation, how to conclude, things like this. So I definitely recommend that you look over this, and I look forward to talking to you again next week.